Good afternoon, Amara. My name is Liam Broadbent and I'm a licensed conveyancer here with Crescent Legal Property Services. How are you going today?
I'm good, thank you. How are you?
Good, thanks. And thanks so much for meeting me here today.
Thanks for having me.
That's okay. So before we begin, I just want to let you know that I'll be firstly taking your instructions and I'll also ask some questions about the lease agreement and the situation that you find yourself in.
Yep.
And at this stage during our meeting, I will provide some preliminary advice based on the information that you give me. However, if any complex legal issues do arise throughout our meeting, particularly around whether that lease is enforceable and your obligations under it, then I might have to refer those questions to a senior lawyer for final confirmation of advice. So does that sound okay before we proceed?
Yeah, that sounds great.
Great. So firstly, are you just able to explain to me in your own words what's happened in relation to the premises and what your main concerns are?
Yeah, absolutely. So in January, Nova Wellness Studio, which is my business, signed a 3-year lease for a newly refurbished space in Leo Bennett's building.
Yep.
We were supposed to open in April and I had already spent a lot on marketing, the staff and the fit out.
Yep.
But in March, the building suffered some structural damage because of underground construction next door. Engineers said it's unsafe and the council has issued a safety notice so no one can access it right now.
Yeah, okay, and thanks for explaining that to me. And just want to let you know that throughout our meeting we'll be taking notes and you're fine with that?
Yeah, absolutely.
Great. So again, thanks for explaining that. So what are your main concerns are at the moment?
My main concerns are I just really want to know whether I'm still bound by the lease.
Yep.
And whether I still have to pay rent.
Yep.
And what really happens now that we can't use the premises.
Yeah, okay. And how's this situation affected you at this present state and your business so far?
It's affected everything.
Yep.
We were about to open,
Yep.
and now we can't operate from the site at all. And I've already invested heavily into the business.
Yeah, okay. And about what outcome you're hoping for in today's meeting? Are you just wanting advice on whether that lease can be immediately terminated and brought to an end? Or whether what your obligations are, and whether you have to continue based on the lease, or maybe you're considering your remedies and what other options and compensation are available to you?
Yeah, I mainly just want to know whether the lease can be ended and if I still have any obligations under it.
Obligations, no worries. And have you received any written notice from council or engineers or your landlord in relation to the safety issues and how long it's going to take to fix those problems in the building?
Yes, I have. I have been told that there is a council safety notice.
Yep.
And that the repairs could take at least 18 months.
Great. And do you have a copy of the lease and the safety notice and any correspondence from your landlord as well?
Absolutely. Yep. I can provide those if needed.
Great, thank you. So based on what you've described to me, there appears to be a written lease agreement, and more particularly, it appears to be a retail lease agreement between your business, Nova Wellness Studio, as tenant, and also Leo Bennett Propriety Limited as the landlord.
Yeah.
So its purpose is to grant your business the right to occupy it, to use the premises in exchange for return for rent. In exchange for consideration and compliance with the lease terms, including the fit-out arrangements and the opening date. So does that sound consistent with your understanding?
Yeah, sure does.
Great. So I'll just briefly explain some key elements of a legally binding contract.
Yeah.
So a contract generally should include an offer where one party proposes terms, acceptance where the other party accepts those terms, consideration meaning something of value is exchanged. So in this circumstance, is the premises in exchange for the rent.
Yep.
An intention to create legal relations. So both parties must intend for the agreement to be legally binding. Capacity, meaning all parties to the transaction must be legally capable of entering into the agreement, such as being over the age of 18 and having sound of mind to be able to transact. And lastly, legality, meaning that the agreement must be lawful, so it just can't be illegal. So in this matter, there appears to be a written lease agreement with agreed terms, obligations of both sides, and consideration being that rent in exchange for the property. The right to occupy the property at least. So on its face value, the agreement does appear to tick all the boxes of the usual elements of a legally binding contract. However, even when those elements are present, enforceability can still be questioned when an unexpected event occurs, such as in this case, where the performance makes the performance impossible, or fundamentally different from what was originally agreed at the time of signing the lease. So does that make sense so far?
Yeah, yep, sure does.
Great. So the main issue here is not whether the lease was valid at the start of entering into it, because based on the information that you've told me, it appears that it was at the time of signing. However, the real issue is whether the lease is still enforceable now that the premises has become unsafe and inhabitable, so unable to be occupied.
Yeah.
And also adding on that those repairs are expected to take at least 18 months. So
Yeah.
a court would likely look at whether the lease can still be practically performed,
Yeah.
and also whether the premises can still be provided in the condition required, and whether the unexpected structural damage and council safety notice has fundamentally changed the nature of what was agreed at the time of signing. So if the premises cannot be lawfully occupied for a prolonged period, then that may be grounds to argue that the lease can no longer be performed in what was originally agreed, and what was originally intended at the time of signing.
Okay.
However, in saying all that, at this stage, I can't provide final legal advice on the enforceability of the lease, because that will depend on the exact terms stated within the lease, and any clauses that deal with damages or access, because there could be a term that said that if the premises is damaged for whatever reason, you're still legally bound. So we just need to read that in its entirety.
Yeah.
And also just to assess the safety notice, and the prolonged period of time that it's going to take to repair the building. And that all those terms should be reviewed carefully by a senior lawyer.
Okay. So the lease may not necessarily continue just because it was signed.
No, so that's exactly correct. So the fact that it was validly signed doesn't automatically mean it must continue unchanged.
Okay.
If the premises can no longer be safely occupied. So if, let's say, if the building wasn't, in the state that it's currently in, then sure, you must legally bind, you're still legally binded by that lease, but because it's changed so much, you might have grounds to challenge the enforceability.
Okay, and so does this mean I'm automatically released from the lease?
No, so not automatically. So that will depend on the exact terms in the lease,
Okay.
and the legal effect on the premises being unsafe, which will need to be reviewed by a senior lawyer.
Okay, and if the repairs take 18 months, does that make a difference?
Absolutely. So the length of the time is very relevant, because it may support the argument that the lease can no longer be performed. So for example, if it was maybe damaged for a month, maybe there's a bit of pushback to suggest that, well, you can perform it in a month. So it being 18 months and being that longer period, it will certainly assist to our argument.
That makes sense.
So in your situation, the important issue is the effect of the structural damage and the council's safety notice on the lease obligations that you agreed to at the time of signing.
Yeah.
So based on what you've explained to me, you've entered into the lease on the basis that you'd like to receive the refurbished and usable premises for the studio, which would include fit-out works and rental obligations, and also that opening date you mentioned, because you mentioned in April, was that correct?
Yeah, that's it.
Great. And so you've also explained to me that you've invested a fair bit of money into hiring staff and also marketing of the business, and also the interior designing of the premises as well.
Yeah.
So the legal concern now is that Leo Bennett may no longer be able to provide a safe and habitable property as required.
Yeah.
Under that lease, and while you are unable to lawfully access or operate from the premises as well.
Yeah.
So these issues that they raise questions about whether the lease has been frustrated, whether obligations such as rent continues on the basis of there's no premises to be able to operate the business from.
Yeah.
Whether either party is excused from future performance, and whether there are any rights to potentially terminate the agreement, and also what remedies may be available.
Okay, and does that mean the landlord has breached the lease?
So potentially, but that does depend on the precise terms included in the lease and the cause of the inhabitability of to be able to occupy the premises. So it may be framed as a breach or frustration or another contractual issue.
Yeah.
However, that does depend on the wording in the lease and also the surrounding facts.
Yeah.
So just moving on to some remedies that may be available. So there are a few that may be available, but just noting that it would depend on the lease terms and the evidence that you have as well. So firstly, there may be grounds to argue that the lease should be brought to an end if it can no longer be performed as what was originally agreed.
Yeah.
You and Leo Bennett originally agreed for a habitable premises, and for you to conduct business on the premises. So as the premises is no longer it's no longer habitable, that's not what was originally agreed.
Yeah.
So second, there may be scope that your future obligations such as rent should be suspended, or simply just no longer apply due to the premises being inhabitable. Sorry, it's a very tough word to say. And also third, there may be scope for negotiation with the landlord to formally terminate the lease, or potentially even vary the terms if that's something that you and the landlord would be open to.
Yeah.
Perhaps maybe they've got another premises you want to conduct your business on, so there may be scope for negotiation there as well.
Yeah.
However, in saying all those remedies, if the matter cannot be resolved, then legal proceedings may then be required to determine whether the lease remains legally binding and also just what obligations continue on both parties.
Yeah.
So the advantages of early action is that you may be able to reduce ongoing losses, and also just obtain clarity before the situation continues any further for you.
Yeah.
However, in saying that, legal costs are expensive, so the disadvantages are also that a dispute may take time, and it may be legally complex and also may heavily depend on the wording within the lease and the supporting documentation. And as a result, it might not result in the outcome that you're after when arguing this. So it could be a lot of legal costs and not result in what you're after.
Yeah, of course. And do I still have to keep paying rent while the premises can't be used?
Yeah, so that's one of the key issues that will need to be confirmed by a senior lawyer for legal advice, as it, again, really heavily depends on the wording included within the lease.
Yeah. And so can the lease just simply be cancelled straight away, or?
Possibly, but again, very similar to the other one, it does depend on the lease wording, and also the effect of the safety notice and whether the legal position supports termination or frustration. There may be a term within the lease that talks about this certain situation, so that's something, again, a senior lawyer would need to advise on.
And can I recover the money that I've already spent on marketing and staff?
Yeah, so possibly, but that would depend on the legal basis for any claim and the evidence supporting your loss, and also receipts. However, just because that's another term that would be really need to be reviewed by a senior lawyer. So after this meeting, I'll make sure I'll raise those points to a senior lawyer for you. So they'll be able to let you know accordingly.
Perfect, thank you.
So there are several issues that I would need to refer for further advice before that final confirmation can be provided. So a few of these would include whether the lease has been frustrated, whether Leo Bennett remains able to perform its obligations under the lease, which in this circumstance it appears that they cannot. Also whether your rent and other obligations continue, whether the lease contains clauses dealing with destruction or termination, which would certainly be important, which is again another reason why we need to review that lease, because should there be a term that deals with destruction, well, that would certainly be important in your circumstances. And also just what urgent action should be taken in light of the expected time frame for the repairs. So while I can provide preliminary guidance today, final confirmation of your rights and obligations and the best way to approach your situation should be confirmed by a senior lawyer after careful review of the lease, the safety notice and any supporting evidence as well.
Okay, so this definitely needs legal review?
Yes, certainly. I would certainly recommend that if you are wanting to bring the agreement to an end at least, because the matter involves the ongoing enforceability of the lease, and also your obligations under it. So that should be reviewed by a senior lawyer so you know where you stand legally, and the best way to approach it.
Okay, and what if the landlord wants to keep the lease on foot?
Yeah, so that may create a dispute. And about whether the lease remains enforceable, which is another reason why a senior lawyer should review that and all the supporting evidence and the lease very carefully. So is that making sense?
Yeah, absolutely.
Perfect. So just so I understand my understanding of your instructions here today. I understand that you would like advice about whether the lease remains legally binding now that the premises is inhabitable. And also whether your obligations remain under the existing lease, and also whether the lease can be brought to an end, and also just what steps should be taken from here. Does that sound correct?
Yeah, absolutely, that's correct.
Great, so thank you so much for meeting me here today. The next steps will be for us to review the signed lease, the council safety notice, and also engineering reports and any other relevant correspondence with the landlord, Leo Bennett. Also just to assess the 18-month repair time as well.
Yep.
Now, after we've received all that, the matter will be carefully reviewed by a senior lawyer, and that at that time they'll be able to provide final confirmation of advice for you to let you know where you stand practically
Yep.
and what your legal options are available to you. And just before that, after our meeting here today, I will send you an advice letter.
Yep.
I'm just letting you know what we require from you and some preliminary guidance, which would also detail that a final confirmation from the lawyer will be discussed in due course.
Fantastic. Thank you.
So that's really everything. Thank you so much for attending here today. Do you have any questions before we leave?
No, that's all good for now. Thank you.
No worries at all. So yeah, if you just send through the lease supporting evidence of the safety notice as well, that'll be reviewed and we'll be in touch.
Perfect. I'll get that to you right away.
Cheers.
Thank you.